Hello, everybody, and welcome to our Hunt and Hunt lunchtime webinar on navigating employment changes. Thank you for joining us today. I normally just give it a minute or two to let people in. We have a huge number of people who've signed up for today, so it clearly shows that it's a very important topic to cover. So I'll just give it a couple of minutes before we jump into the content to let those people in. If you're already here today, very prompt, thank you for joining us. Some quick housekeeping. This is being recorded and we will be sending around the video as well as the presentation in the next couple of days. So you can feel free to share that around with whoever you want to, because we're happy to share any information. You're also very welcome to ask questions in the chat function, in the Q&A function. If you're having any problems hearing me or with the presentation, just pop a comment in the chats and we'll address it, but pop your questions through the Q&A. We might be able to get to it throughout the session, but also there's a section at the end where we'll answer the questions as best as we can, provided we're still in the time frame. But as always, you're welcome to reach out to us. So I am Sarah Capello and I'm the managing partner in New South Wales. Hunt and Hunt is a full service firm with a national footprint and our ethos is genuine people, practical solutions. I run the commercial team here at Hunt and Hunt and we cover all things business related. I'm joined today by my fellow partner, Joey Tass. Many of you know Joey was recently promoted to partner and he now runs his own commercial practice. So thanks, Joe.
Hey guys, thanks for jumping on. Thanks, Sarah.
And congrats, first time presentation as a partner. He's received many emails, congratulations, and it's very well-deserved promotion.
Thank you.
So, a lot to cover today. We've had quite a few people asking for a quick recap, as there's so much happening over the past 2 years in this space. And so for some of those of you who've attended our earlier webinars, you might see that we're covering some of the old ground, but we're only going to touch upon that stuff very quickly, just as a quick reminder of what's happened. And then we'll be talking about some key dates from 2023 and mainly the key dates for 2024 before we get into the focus topics of the right to disconnect, defining an employee, and all of the changes to the union rights. So there's a lot to cover today, and a lot of it is really topical at the moment. I'm sure a lot of you are following the news to see particularly the right to disconnect. A lot of people saying, what does that mean? Can I email my employees outside of business hours? And also, can I, as an employee, should I be answering the phone? And also, obviously, with the unions. Again, there's a lot happening with the unions and what that might mean. So it's good to kind of get across these topics. So as I said, we will be covering some old ground, but we're not going to be focusing on it too much. I just want to quickly add too, my apologies in advance for this cough. It's been lingering around for a couple of weeks like many people, but I'll try my best to keep it in. So as you can see, the legislators have been incredibly busy over the past few years. This is not an exhaustive list, but just some key pieces of legislation that it really is the source of our presentation today. The main one we'll be talking about is the Fair Work amendments, and there's also been a lot of discussion about work health and safety as well as discrimination. So just really quickly touching upon the discrimination amendments, which was known as the Respect at Work Act. That aims to protect workers and empower them to address unlawful sexual harassment in the workplace. So I'm not going to talk about this in detail because we've already covered it in previous webinars, but just a quick reminder, the Act imposes a positive duty on businesses to eliminate, as far as possible, certain unlawful behaviours related to sex discrimination in the workplace or in connection to work. And this came into force in December 2023. So if you're not across it already, you really need to be, and we've got a link later on to our previous webinars, and you can of course reach out to us to get that information. So that's a really important one to note. A new one, which is listed at the bottom of the slide, is the Industrial Manslaughter Act, which was passed just recently on the 20th of June 2024. So this act amends the Work Health and Safety Act, creating an industrial manslaughter offence. So under this new legislation, persons conducting a business or undertaking and their officers will be held accountable for grossly negligent conduct that breaches their work health and safety duties and causes the death of an individual. So with this change, New South Wales joins the other states with similar laws targeting those with gross negligence, whose gross negligence results in a worker's death. There's no time limits for prosecutions, and it sets unprecedented penalties to enforce workplace safety. So you must now take proactive steps to ensure you're meeting your safety obligations to avoid those serious consequences. So again, if you're not across this really important legislation, make sure you get across it. So a lot of the focus today will be on the closing loopholes number 2, which was passed earlier this year. It happened relatively quickly, and you might recall that the right to disconnect was snuck in at the last minute, but that actually has been the basis of a lot of questions that we've had from clients and referrers saying, what does it all mean? And Joey's going to cover that in a lot of detail. But we'll also, if you need information about the closing loopholes 1, which was equally as important, go back to our earlier webinar, which we'll have a link on. So key dates. So we've outlined here some key dates prior to 2024, and in the next slide, we've got 2024 on. So this list is not exhaustive, but we've just picked out the ones that we think will be very relevant to you and to your businesses based upon who we know is in the room today and just kind of the makeup. So I want to really talk quickly about the oldest change, which happened in October 2022, which was the introduction of the Work Health and Safety Regulation Amendment that deals with psychosocial risks in the workplace. So I want to mention this because we've not presented it publicly on this topic yet, but we have done it privately for some clients who've asked for advice and guidance, because there's an increased importance on managing mental health in the workplace. So very quickly, the updated regulations address psychosocial harm and requires the identification of psychosocial hazards, which can range from things like increased job demands, low job control, poor support, a lack of role clarity, and then things like bullying, harassment, violence, and conflict in the workplace. So these amendments require the recognition of hazards that can create stress, and if that stress remains high and prolonged, it can lead to injury. So a person conducting a business or undertaking now must eliminate psychosocial risks, or if it's not practical to completely eliminate them, they need to minimise them as far as reasonably practical. So again, this is an important one to look at with managing the work health and safety requirements in that area. So back to the Fair Work changes. So again, take some time. We'll send these slides through. You can read through some of these additional changes and just reach out to us if you've got any questions. But now focusing back on the Fair Work Act, kicking off the new financial year, a number of changes came into effect. The biggest one was the minimum wage increase and the award rate increase by 3.75%. We sent around a notice to everyone about that, just as a reminder. So the national minimum wage applies to employees not covered by an award or registered agreement, and that rate's increased to $24.10 per hour, or $918 per week. For any employees covered by an award or a registered agreement, they're entitled to minimum pay rates that are set out in that award or agreement, and those have increased by 3.75% as well. So if you pay minimum or any award rates and you've not updated your payroll, you need to be doing that ASAP to make sure that you're complying and you won't have an underpayment claim. So there's also, there's a lot of changes relating to unions and delegates, and Joey's going to be talking about that later in the presentation. Another one on the dollars is the increase in the super rate to 11.5%, which came about on 1 July. As many of you know, this rate is increasing until it gets up to 12%, which will be on 1 July 2025. Again, with the dollars, the high income threshold has increased. Now, this is relevant for a number of reasons. The first, and this is in the space where Joey and I operate, is with any employment disputes, which is mainly unfair dismissal claims. So for some of you might know that there's 2 threshold questions that you need to ask in these cases. One is how long they've been employed, and the second one is what their earnings are. So the high income threshold has increased the earnings amount to $175,000. Earnings does not include super, but it can include things like non-monetary benefits, like a car, for example. So you need to be looking as to whether your employee, or if you are under that threshold or over that threshold, and if so, you're not going to be entitled to bring an unfair dismissal claim. It also impacts the amount of compensation that you can be awarded for a dismissal claim. So from an employer perspective, that's increasing the potential damages that you'll have to pay if you're found to have unfairly dismissed an employee. So it is important in that context. And the last thing is whether an award will apply, because there is a high income threshold that it can apply to that. So 26 August is also another big date to keep in mind. So we've got the right to disconnect. And again, Joey's going to be covering that topic because it is a really important one. Then we have the change in definition of an employee, as well as the casual employment or casual employee. So I'll be talking about that later on and what that might mean to you. And then we've got changes to regulated workers. So we're not going to be dealing with that today because that alone is a standalone webinar. But I'm going to be passing over to Joey now, who's going to tell us about the right to disconnect.
Thanks, Sarah. So look, the various employment changes, as Sarah's just touched upon briefly now, impact all workers and has created a heightened era of compliance. So importantly for employers, they're going to be required to exercise greater caution and devote more attention to ensure compliance with these new changes and obligations. Now, the right to disconnect changes comes into effect the 26th of August this year, or the 26th of August next year for small business employers that have less than 15 employees. It's probably fair to say that the right to disconnect changes has been one of the most controversial of the changes, and certainly the one that has attracted the most media attention. But what does it mean? That's what a lot of clients are telling me. What does it mean? Can employees refuse to respond? Can they just, shut it out and just wait till the next day? What does it all mean? So put simply, the right to disconnect changes allows employees governed by the Fair Work Act to have the legal right to refuse to monitor, read, or respond to contact from their employer outside of the employee's contracted working hours, unless the employee's refusal is unreasonable. And that is the key point here, whether their refusal to respond is unreasonable. This right also extends to third parties such as customers or clients. So it's just something employers and businesses need to be aware of. So the right to disconnect extends to things such as work-related calls, text messages, instant messages, emails, and other forms of contact by the employer outside of the employee's working hours. So it doesn't mean, from an employee's perspective and managers and the like, it doesn't mean that you cannot send emails or text messages to employees outside of their working hours. It doesn't mean that you cannot call an employee outside of their working hours either, or that you'll be penalized or, subject to fines or things like that. Rather, the right to disconnect changes ultimately means and gives the right to employees to choose not to respond to the contact to the out of hours contact in certain situations. So the Fair Work Commission, as of last week, has issued a statement that it will be implementing guidelines concerning the right to disconnect after the changes have come into effect. So after the 26th of August this year. And once the Fair Work Commission has dealt with at least some of the disputes concerning the operation of the right to disconnect changes, in order to allow the Fair Work Commission to have some sort of understanding as to the practical issues for which then they will provide some guidance on. So over to the next slide, the part where I've sort of defined the definition in relation to, what is a reasonable refusal. So similar to the regime under the Fair Work Act in relation to working additional hours and the criteria which determines, what makes it reasonable or unreasonable to refuse working additional hours, under the right to disconnect changes, an employee can only exercise their right to disconnect where it is not unreasonable for them to do so. So the new provisions have a set of criteria to assess whether an employee's refusal to respond to contact will be unreasonable. So these include, the reason for the contact or the attempted contact, how the contact or attempted contact is made, and the level of disruption the contact or the attempted contact causes the employee, the extent to which the employee is compensated, whether through monetary or non-monetary means, to either remain available to perform work during the period in which the contact or attempted contact is made, or for working additional hours outside of the employee's working ordinary hours of work. It also includes the extent to which the employee, it also includes the nature of the employee's role and the employee's level of responsibility, and the employee's personal circumstances, including family and other caring responsibilities. So the criteria I've just sort of touched upon isn't an exhaustive list, as is always the case when it comes to these sorts of things, and therefore does not limit other matters that may be taken into account by the Fair Work Commission in determining whether a refusal by an employee is unreasonable. And like I've said, when the guidelines, do come out, it may be other issues or other circumstances in which may be addressed in these sort of guidelines. So in simple terms, the right to disconnect changes means if an employee was to ignore out of working hours communications, so long as that behavior is not unreasonable once having regard to the various circumstances as just touched upon, they cannot be punished for it. That is the crux of it. So whether an employee's refusal to respond is reasonable or unreasonable, will therefore, vary depending on the employee's individual circumstances and the nature of their role. So looking at it broadly, it's probably expected that employees in more senior roles or with greater responsibilities will have less of an opportunity to reasonably exercise the right to disconnect. Senior managers and etc. will be more reasonably expected to be available to respond to work-related communications because they have that high level of responsibility and communications, and generally speaking, they're compensated more. And there is that expectation in these instances, especially the high-level management, to remain available for urgent or time-sensitive matters. On the flip side, it might be more reasonable for a lower-level graduate or salaried employee with less overarching responsibilities to exercise their right to disconnect. So sort of they're two broad ends of the field in relation to, whether it's reasonable or unreasonable to expect someone to respond to out-of-hours contact. So the right to disconnect changes will now be a workplace right, which is very important for all employees to know. So it will be a workplace right under the general protections regime of the Fair Work Act. What this means is that employers must not take any adverse action against an employee. And adverse action means things such as dismissing the employee, subjecting the employee to disciplinary action, or discriminating against the employee on the basis that that employee reasonably exercised their right to disconnect by not responding to work-related communications outside of working hours. So the right to disconnect changes will also be incorporated into modern awards to include a new model term, which I'll shortly touch upon. And it also includes, the right to disconnect changes is also important to recognize, it's also important to recognize that an employer will not automatically contravene the new right to disconnect legislation by contacting or attempting to contact an employee outside of working hours. So, like I said, it just depends upon whether a response is expected or not, and whether it's reasonable or not for the employee, whether it's reasonable or unreasonable for the employee to respond to the out-of-hours contact. So I'd expect changes will likely encourage employers and employees to acknowledge the issue more and set boundaries as to whether there is that expectation to respond or not in relation to out-of-work hour communications. So over to the next slide. The right to disconnect changes incorporates what is called the introduction of a formal dispute resolution framework for disputes about the operation of the right to disconnect provisions, including disputes about whether an employee's refusal to respond to or engage with contact is unreasonable. So the first step always is, in these sorts of frameworks, requires the employer and the employee to attempt to resolve the dispute within the workplace. If workplace level discussions do not resolve the dispute, then either the employer or the employee can refer the dispute to the Fair Work Commission. Now, the Fair Work Commission has broad powers if a dispute arises in its jurisdiction to either order the employee to stop refusing to respond, if it's determined that the employee ought to respond to out-of-hours contact, depending on, again, the circumstances as a whole, or they can order the employer to stop requiring the employee to respond, or they can order the employer to not take disciplinary action against the employee on the basis of the employee exercising their right not to respond, and that is reasonable. So if the Fair Work Commission makes any order and such an order is breached, then civil penalties will apply. So over to the next slide. As I was touching upon in relation to model terms, the Fair Work Commission last week circulated a draft modern award term for the right to disconnect changes. So this will sort of give you sort of a brief understanding as to what the Fair Work Commission is envisaging in relation to introducing model terms in all the modern awards. So the term that has been developed in this instance, as shown on the slide, has been developed for the Business Equipment Award 2020. At this stage, it is a draft model term, so interested parties are free to file any submissions concerning these draft terms by the 1st of August, and the Fair Work Commission will make a final determination varying the modern awards in respect of the Right to Disconnect terms, which will be published by the 23rd of August and ready for commencement on the 26th of August. So, what do the Right to Disconnect changes mean for employers? Practically, the right to disconnect will create challenges, in my view, for employers as different perspectives or views between employees and employers as to what constitutes unreasonable refusal of contact will undoubtedly create tensions in some workplaces. But a few important things to consider in light of the changes would be as follows. So first of all, consider the forms and the extent of outside working hours communications currently sort of used or implemented, and whether these could be claimed as unreasonable by an employee, and if so, ways to work around this. So defining the terms, looking at what they're remunerated, setting the expectations about whether they should respond or not, and things like that. Also managers and key decision makers need to be across these right to disconnect changes and how it interacts with the general protections provisions of the Fair Work Act in order to avoid any claims being brought by an employee who believes that adverse action has been taken against them due to them exercising their workplace right to disconnect, whether that's a dismissal, whether that's a demotion, whether that's discrimination or the like. So, they're things that employers and managers and key decision makers need to be aware of. Managers can also utilize technology in their communications with emails, for example. So scheduling, like myself, I'm sort of prone to this. I regularly send emails to all parties and my colleagues and the like out of hours because it works with my schedule. But one way it can be done is scheduling those emails, notwithstanding I'm sending them out of hours, scheduling those emails to be sent during work hours, for example. That's one way, or alternatively, you can have in emails, for example, in emails that are sent out of hours, just a short line saying, you don't expect a response to be provided immediately, and it can be provided during the employee's ordinary work hours.
For me, Joey, so then you don't have to email me 50 emails at 11 o'clock at night.
Sorry, what was that?
It's great news for me, so that I don't get 50 emails from you 11 o'clock.
You'll get them 9 a.m. the next morning.
Great news.
So,
sorry, dude.
Yeah, so yeah, I'm prone for that. So if you ask anyone what time I send the emails, they'll tell you 10 o'clock, 1 a.m. in the morning, or the like. So anyway, that's just me. And then, another one is employers ought to review and update their employment contracts where necessary, as well as create policies and or guidelines, which establishes, that transparent workplace and expectations as to, out of hours contact and things like that. So it's just more so about talking about the, these things because they are going to come to light on 26th of August. And there will be some issues and tensions I would expect in relation to the expectations by employees in responding or not to these out of hours contact. Now, over to you, Sarah. So I understand you'll be discussing the next part of the changes in relation to new employment definitions.
Thanks, Joey. The topic you were just talking about, though, is incredibly interesting, I find, because obviously technology means that we're always connected to our workplace, but I can see why the government are wanting to take steps to try to, recognise that constant connection to try to, address all of the issues that I mentioned earlier, like the psychosocial risks and whatnot. But as you said, you have to look at every circumstance and see if it applies for you. For our practice, talking outside of hours is pretty commonplace, but really it's about whether I respond to you or not. In most cases, I don't because I'm fast asleep. Anyway, moving on to another really important topic of who is an employee, and we're going to be talking about the definition of employee under the Closing Loopholes number 2 amendment. So on August 26, a new definition of employee will be inserted into the Fair Work Act. This is a pretty significant reform because it's incorporating a previously known concept to distinguish employees from independent contractors. So a very brief history lesson on the roller coaster that is employment law. Historically, there was a multifactorial test which evaluated the overall relationships between parties, focusing heavily on the aspect of control. And it's not that the contract was disregarded as such, it was that the courts looked beyond the written terms. And this often confused employers who hired people and classified them as sole traders or independent contractors under often a well-drafted written agreement. But if they treated them at all like employees, the employer was exposed to the risk that they could end up owing more entitlements such as leave, super and penalties if it was ultimately determined that they were employees. So it was a very big grey area. So along came a case, a High Court decisions in personnel contracting and JAMSEC, which shifted the focus to the legal contract between the parties. So that limited the consideration of the actual working practices. It wasn't disregarded, it was just more focused on the legal contract. So that was the case for a few years, but now the new amendments shift the focus back to the earlier position by reverting to the broader evaluation of the real substance, practical reality and true nature of the relationship, considering both the contract and how it is performed in practice. So what I find really interesting about this is you'll see the note on the slide, this is just a cut and paste from the legislation. There's a note that references that it is specifically in response to those cases I mentioned earlier. So it can't be any clearer. It's abundantly clear that this amendment is addressing the outcome of those cases. So what we have now, we've reverted back to that somewhat uncertain position where the contract is not quite as important as it was for that short time. So what does that mean in practice? So there is some opinion that the new definition causes more confusion for employers and sometimes even confusion for us lawyers. So in reality, we often get asked the question, is this worker an employee or an independent contractor? And in true typical lawyer form, we always say that the answer is complicated and it depends upon the many circumstances of the case. So taking a step back for a moment to explain why it's so complicated and why we give that answer, there are multiple definitions of an employee. So there's the common law definition. There's also the employment-related legislation, which includes just the definitions such as the Fair Work Act, the Superannuation Guarantee Act, you've got Long Service Leave Act, you've got Workers' Comp, and that doesn't even include the tax legislation, which falls way outside my area of expertise. But I wanted to mention it to emphasise the vastness of the employment space. So if we just focus on the definition for the new definition for employee under the Fair Work Act and how it can be considered in the context of employee versus independent contractor, the Act now tells us to look at the real substance, practical reality and true nature of the relationship. So although there can be a really clear and well-written contract, it might not matter if it does not accord with the reality of the situation. So you can come to us, we can draft you the best ever employment independent contractor agreement ever, but if it's not what's done in practice, then the courts will look beyond that. So remember that only applies, this new test only applies when looking at an employee under the Fair Work Act. And there are other tests that might apply when considering things like superannuation, workers' comp and long service leave. So it's pretty conceivable that there'll be somebody who is deemed an employee under one legislation, but an independent contractor under another, just to make life hard for everybody. So there are some significant consequences of getting it wrong though. So if a business thinks that they're paying someone as an independent contractor and ultimately it's determined that there's an employee, they might have to pay additional entitlements like super, for example, as I mentioned. Also, there's ramifications for dismissal, so termination, because sometimes the unfair regime will still apply to that person who you believe is an independent contractor who might be deemed to be an employee. So thankfully, the government have turned their mind to the question of the entitlements and said that the back pay for underpaid entitlements will not arise for workers who were contractors under the old version of the Act and will change their status to employee as a result of the amendment. But the new definition, which will apply from the 26th of August, is now going to be implemented. So you need to turn your mind to this really now. There is an opt-out provision that can apply to those earning the contractor high income threshold who exceed that amount. However, that amount is actually yet to be determined, so it is a bit of a grey area. So unfortunately, we don't have enough time to get into the further details of the independent contractor discussion that's set out in the Closing Loopholes 2, but I just wanted to really quickly mention a couple of the areas that it covers, which is sham contracting, unfair contract terms for independent contractors, protections for regulated workers. So this is really focusing on the gig economy and also contractors in the road transport industry. So if any of those apply to you, those 4 topics, reach out to us. We can provide more information. It's just that they're a little bit more specific than what we wanted to cover today. But for today, we want to focus on more universal concepts, and one of those included is casual employment. So another really quick history lesson, you might have remembered hearing about a High Court case referred to as Rosato. So in that case, the High Court ruled that the primary consideration in determining how to characterise the employment relationship for casuals is by considering the express terms of the written employment contract. So similar to what I discussed earlier, with the new amendments, the focus is going back to not so much on the written contract, but other criteria. So from 26 August, an employee is a casual employee only if, one, there is an absence of a firm advance commitment, and two, there is an entitlement under an award or enterprise agreement to be paid casual loading or a specific rate. So when looking at whether there is an absence of a firm advance commitment, which is the first limb that I mentioned, we need to look at, again, what is the real substance, practical reality, and true nature of the relationship? So this means looking at the totality of the relationship and not just the employment contract. So things that might indicate a firm advance commitment. So this is a kind of common thing that comes up, and most people are aware of this concept, but the definition kind of sets out some factors that you might want to look at, and that is, can the worker elect not to accept work on a particular day, or and also, are they able to say, no, I can't do that day? What is the reasonable likelihood of future available continuing work? So what's the likelihood that they're going to be needed in the future? Also, look at what other permanent, the courts will look at what are the other permanent employees doing, and are they doing the same job? So if you've got two employees, one is a casual and one is a permanent employee, and they're both doing the same job, then that might indicate to the court that the casual should be classified as a permanent employee. And of course, this is one you might have heard, is that whether there's a regular pattern of work. So all of those criteria do not need to be satisfied in order for somebody to be determined a casual or not. It's just the legislation is setting some factors out to consider. And if you just look at, for example, just a regular pattern of work, if a casual employee has a regular pattern, that fact alone might not mean that they are they're a permanent. They could still be a casual even if they have that regular pattern. It's looking at the totality of the relationship. So just to kind of put it in clear terms, if you have a regular roster and a person is scheduled on that regular roster, that might not mean that necessarily that they're permanent. They can still be casual. You have to look at whether there's that firm advance commitment for ongoing work. So now, just to make matters even more complicated, you can have, once you kind of determine that somebody is a casual, we then have the casual conversion regime, which is not a new concept, but it has changed under this amendment. So there's new casual conversion choice process where employees may exercise a choice to convert, provided they meet a series of tests and follow the process. The process includes issuing a written notice after being employed for 6 months or 12 months for small businesses. The employer has to respond within 21 days, and they also must consult with the employee as well. So there are grounds to not accept a notice from the casual employer, and that includes things like if the employee still very much meets the definition of casual, or if there are fair and reasonable operational grounds for declining the offer. So a lot of businesses are concerned about casuals and the prospects of them seeking to convert to a permanent employee, because then, just to kind of put this in kind of real terms, the ramifications will be then if you need to then make that employee redundant or terminate them, then that does create more onus on the business, particularly if it's, for example, seasonal work and that kind of thing. So if you've got an employee who's harder to terminate because you don't need them, then you'd have to be paying redundancy, which adds an additional cost. So sometimes there's an important case for why you could still employ casuals, and sometimes there's not. So the Act is just addressing these instances. But there are many instances where employees don't want to be converted to permanent. They would prefer to be a casual employee, and that's because you obviously get the casual loading, and they get a higher amount in each of the hourly rates. So it's not as we don't see this as common in practice in terms of people coming to us, but it is still there, and we need to turn your mind to it, because if you do get it wrong, there are penalties that can apply. So if you do ever need help, reach out to us and we can have a chat. So quick summary of the definitions at this point. As you can see, there are a lot of changes happening, and we are touching upon them at a very high level because of the time constraints today. But what I really want you to take away from this is that now is the time for you to review your workplace practices, and in particular, the status of your employees, given the change in the definitions. think about whether you need to take action. Look at whether you've got independent contractors, look at whether you've got casuals. If you're not sure about whether they're going to be impacted by these changes, get advice from us if you're uncertain, and then look to see how we can make sure that you're compliant with the legislation. So a lot to unpack, and then on to an even more hot topic at the moment, which is on unions and delegates. I'm going to pass back over to Joey to talk about this.
Thanks, Sarah. Yep. Okay, so yes, another hot topic. Workplace delegates. So yes, workplace delegates was one of the bigger changes out of the Closing Loopholes Part 1 reforms, which is, it effectively gives new rights and powers to workplace delegates. So the Closing Loopholes Parts 1 and 2 was initially implemented to close some loopholes. One of them being, obviously, as Sarah sort of touched upon, the multifactorial test and things that came out of judgments, and the government, ultimately was like, okay, well, we need to, these were some loopholes that were created, we need to close them. However, in my view, these workplace delegates changes aren't really closing any loopholes, so to speak, but they're more so giving more powers or rights to delegates and unions in the workplace. So what is a workplace delegate? It's different than a union. A workplace delegate is an employee within the business who forms part of an employee's organization and who is either elected or appointed to be a representative within that workplace. So employee organizations typically include unions and other registered organizations. The workplace delegate is entitled to represent both employees who are part of the union as well as anyone else eligible to join the union within that workplace. So it impacts a broad range of people. Of course, no employee is compelled to have a workplace delegate represent them if they don't want that, person to represent them. And such employees can have their own support person or even a paid lawyer or agent of their choosing if they want in any sort of workplace disputes. The representation that the workplace delegate is entitled to provide is in relation to employee industrial rights. So it's quite broad. It can be anything from pay disputes to rostering, hours of work, penalty or overtime pay to flexible work arrangements. So it can be, a broad range of things in which an employee can have a workplace delegate there to represent their interests. So the likely point of this new law is to get more union delegates on work sites in relation to employee industrial disputes. Although, as I've just said, employees aren't compelled to have a union delegate there to represent them. So over to the next slide. The Part 1 closing loophole reforms will now require employers and businesses to afford many more rights to workplace delegates, which include the following. So in respect of these workplace delegates, the right to represent the industrial interests of current and prospective members, reasonable communication with current and prospective members in relation to their industrial interests, reasonable access to the workplace and workplace facilities for these workplace delegates to conduct their duties, and reasonable access to paid time during normal work hours to undertake paid training in relation to their workplace, in relation to their role as a workplace delegate. Now, this is only to larger business employers. So small business employers are excluded from this obligation. Now, the new laws in relation to workplace delegates are now classified as workplace rights under the Fair Work Act, similar to what I briefly touched upon in relation to the right to disconnect. Meaning, so in relation to workplace delegates, it means that an employer may be subject to damages and penalties if they don't comply or take adverse action against a workplace delegates in the workplace delegates exercising their rights as being a workplace delegate. So again, similar to if you take adverse action in dismissing this workplace delegate, demoting them or treating them differently or discriminating against them because they're a workplace delegate and they're exercising their rights now as a workplace delegate, then that employer may be subject to a general protections claim. So the reasonability afforded by employers in relation to the obligations of communication, access to workplace facilities and paid training as I've just mentioned, regarding these workplace delegates will largely depend upon the size of the employer's business, resources, and facilities that are available at the time. So obviously, it will largely depend on, all these various factors in respect to the business. So also, the duties to be undertaken by the workplace delegate are to be undertaken without loss of pay. So I absolutely appreciate from an employee's perspective, you may be thinking that at the time this employee was employed by the business to do their job, it was to do their job and not to be a workplace delegate. However, these closing loophole reforms now means that elected workplace delegates have these extra responsibilities, and they must be afforded the rights, that are afforded to them in relation to the time and the facilities and the duties without loss of pay. That is the reality of the situation, and that is something that employees ought to be aware of. And again, it impacts different businesses depending on the size and the resources available. So it's just something that you need to be aware of. And obviously, if it ever occurs and you're not sure, go seek the right advice, and we can help with that. So the workplace delegate rights are now in effect, and they are set out in the provisions in the Fair Work Act, and compliance is therefore mandatory. Modern awards have implemented these workplace delegates terms as well from 1 July. So if you're, got employees subject to any specific modern awards, open that, have a look. There will be modern terms in there in relation to workplace delegate rights. And provisions requiring enterprise agreements to include delegates' rights terms will also apply to enterprise agreements where a vote has commenced after 1 July, and provided that vote is successful and the Fair Work Commission approves that enterprise agreement. Now, if you are subject to an enterprise agreement and there are no workplace delegate rights terms in those, then it would revert back to what the terms are in that respective modern award. So that's just something to have a think about. Now, over to the next slide. So from an employee's perspective, it's important to understand that the workplace delegate changes will only affect your workplace, once you're informed that someone has been appointed as a workplace delegate and an employee wants them to represent them in relation to an industrial dispute, whatever it may be. So you can't turn a blind eye. And as an employer, you need to, obviously, again, like I said, be aware of these changes. So what can employers do regarding, these changes? Importantly, first of all, employers should ensure that there is compliance with these new workplace delegate laws by reviewing and updating all of their internal policies and procedures, and making sure that their employees, in particular upper management and decision makers, are across these obligations and rights that must be afforded to these workplace delegates. The last thing you want is situations where, these workplace delegates have these rights, need the access to resources and communication and workplace facilities. And, for whatever reason, you may have, people in management who may not be aware of these new laws and, make certain decisions which may be classified as adverse action. And then you'll be embroiled, if this workplace delegate brings a general protections claim, for example, then your business will be embroiled in litigation. And that's something obviously you want to avoid. So in these instances, it's just important to be aware of these changes, what they mean, how it impacts your business, and obviously what you do moving forward to minimize any risks and any changes that may need to be implemented in relation to these workplace delegate laws. So, yep, that concludes, I guess, the changes in relation to workplace delegates. Over to you, Sarah.
Thanks, Joe. So I've just been answering a couple of questions that have come through, and one of the questions come up about the right to disconnect. So the question is, actually, before I get to that, I might just quickly mention that we have talked about some previous webinars that we've done before, which covers the closing loopholes part 1 as well as part 2. So our part 2 webinar we did together with our Melbourne team and was more of a panel discussion about how it might take effect. So this is kind of drilling a little bit more down on the elements of each aspect. But we'll send this through in the registration, later on to anyone who registered, so you can access that later on. And that might answer any more questions you have about some previous aspects of the amendments. But just getting to the questions now. So I've answered a couple on the spot. A question was, and this is a good reminder to give the definition about what is a small business versus a large business. So what we're referring to in this presentation is the definition of small business under the Fair Work Act, and that is a business with less than 15 employees. So we've also got that's really important to know whether this is the time frames are going to apply to or not, and also whether some of the responses you need to provide, how onerous you need to be. So there's a lot of exemptions that apply to small businesses. The question about the right to disconnect was about having that policy and whether it's worthwhile having some practical examples. So, I mean, I personally think, yes, it is a good opportunity to have some practical examples in a policy. And Joey, please do weigh in as well. But, you know, any policy has to be really applicable and relevant to your business. So that policy might want to set out, you know, how you actually operate and what would be acceptable and what's not acceptable. And it's really handy to have those examples so people can understand how it can be applied. But policies, you know, should be constantly reviewed and adapted to make sure that it's compliant. And also the main thing with a written policy is to make sure that you're applying that in practice. It's all good to have these great looking policies on your systems accessible, but if it's not actually being followed, then that's the key. So the answer is yes. I think you're definitely better for having some case studies, give some examples, and you know, just to kind of consult constantly with your employees to make sure it's being followed.
Yeah, I echo that. It's just important to I just go back to the transparency. So the transparency in relation to any policy or any communications that I had of the expectations of all employees within the business, and those that, you know, are required to you know, respond to out of hours contact, and those that aren't. And then the next step is really those that are assessing whether it's reasonable to require them to respond to out of hours contact. And that comes back down to, you know, their role, their duties, their remuneration, you know, and things like that. So it's sort of I think to answer the policy, that's good, but also assessing whether those that you require to respond to out of hours contact, you know, whether you can require them, and whether and that's again where I talk about the various factors that come into play.
Yeah. So we've covered, as I said, quite a lot today. Thank you very much for taking the time to join us. If you've got any more questions, then here are our contact details, and we would love you to get in touch with us. Please feel free to reach out anytime. There's our email addresses, and we do really love talking about this stuff. There's always a lot of changes in the legislation coming up, and this does have consequences, quite significant consequences to businesses, and we want to be able to be a sound resource just to even pick up the phone. But you know, as I said, there's a lot to unpack. We'll send through the information and reach out to us whenever it's needed. Thank you, guys. And we finished on time, which is a change, which is great. So you guys have some time to go and grab some lunch before we finish off. Have a great day, everyone. Thanks,
guys. See ya.